Calling case number 25-000876 FY, people of the state of Michigan versus Tamela, Peterson. Appearances for the record, please.
Thank you. Good afternoon, Your Honor. It's Assistant Attorney General Chris Kessel for the people.
Good afternoon, Your Honor. Gerald Gleason on behalf of Ms. Peterson, who is standing in the jury box.
Thank you. Ms. Peterson, state your full name for the record. Thank you.
Yeah, if you want to know roughly what happens in a hyperbaric chamber, have you seen the movie Deadpool? Where he transformed into Deadpool with his entire body burns at the same time? Yeah, because the hyperbaric chamber is filled with pure oxygen. There is nowhere to go, and everything catches fire at the same time. Sadly, this 5-year-old did not become Deadpool. He become, yeah.
This is an arraignment on the information. How are we proceeding?
Your Honor, I'll acknowledge receipt of the complaint, waive its formal reading, and she will stand mute to the charges.
All right. I'm indicating a waiver of the formal reading of the complaint. A plea of mute will enter to the charged offenses. As these are felony offenses, you do have the right to a probable cause conference within 14 days. That is scheduled for March 19th, 2025 at 2:30 before Judge McGinnis. You also have the right to a preliminary examination. That is a hearing in which the prosecutor has to establish a probable cause that a crime was committed and probable cause that you committed it. And that will occur on March 26, 2025 at 9 a.m. You have retained counsel had you been unable to do so and declared indigent or unable to hire an attorney. One would have been appointed for you, as you do have the right to be represented. You also have the right to remain silent. Anything you say orally or in writing can be used against you in court. You understand? All right. So I've entered the plea of not guilty. The next two court dates have been established. The next issue that needs to be addressed is bond. I will hear first from pretrial services, and then I will speak with you two.
Yes, Your Honor.
Brenda Rogers, pretrial services. I did not interview the defendant. She did decline requesting her attorney. Therefore, no references were contacted and limited background information was obtained. Records show she's 58 years old, have an address in Brighton, Michigan. Information regarding to employment history, use of alcohol or drugs, or any physical or mental health conditions is unknown. The defendant has no prior criminal history on record. She has no outstanding warrants.
Okay, so this is the full arraignment. Then I found what we can watch afterwards. They have a hearing that is just 2 weeks ago. So we can find out more about this case.
No pending matters or holds. And given that there is great concerns for the allegations and the presumption of innocence, the defendant does appear to have a stable residence in Brighton. She does appear to be gainfully employed and has no prior criminal history or history of failing to appear. Therefore, it is respectfully recommended that she be released on personal bond. And it is respectfully recommended the following conditions: pretrial services, no possession of a firearm or dangerous weapon, no contact with the co-defendants in this matter, not to return to any Oxford center, and that she must surrender her passport to the court within 24 hours of release.
Thank you. Counsel?
Thank you, Your Honor. I think obviously it goes without saying the seriousness and quite frankly the tragic nature of these offenses, go without saying. What I would ask the court to take into consideration is, first, when we talk about bond, one of the conditions the court is to consider is protection of the public. Now, this isn't your typical murder charge in the sense that there weren't specific acts of violence perpetrated by this defendant, but the people's concern regarding the protection of the public, Judge, is this defendant owns and operates another location where this hyperbaric oxygen treatment is taking place. And the people believe that the continuing operation of that business poses a serious threat to the public. It is only by the grace of whoever that this hasn't already happened before. And so the people would ask this court to impose a bond condition that this defendant not have any conduct supervising, overseeing anything related to the business of hyperbaric oxygen treatment, because it's the people's position that the defendant, in her lack of care, is responsible for what happened to the victim in this case, and allowing her to continue to run those businesses the way she has been for years only puts multiple other potential victims in harm's way. I do agree with the pretrial services judge. Obviously, because this defendant has no prior record, there is no history of failing to appear. But with this defendant, much more than any other judge, the people are concerned that she is a flight risk. What I will tell you, Judge, is that as part of our investigation, the people discovered that recently the defendant applied for and got a visa to China, which is still active at this time. She also recently purchased an amount of uncirculated Iraqi currency, which is very concerning to the people, especially considering the defendant has ties.
Oh, this is strange. Now, a visa to China, yeah. Not on. I mean, if she works with centers that has these hyperbaric chambers, of course she needs a supplier and everything. So that's not strange. But Iraqi currency, that's weird.
To people out of the state and out of the country. I would also point out, Judge, that days after the explosion, the defendant admitted to wiping her laptop. She lied to investigators to prevent access to video of the explosion in this case. And a previous investigation reveals that this defendant has told other IT tech in her business to wipe devices to essentially destroy evidence involved in other investigations. Judge, I would note that there are witnesses in this case who I and other investigators have personally spoken to that indicate that this defendant has bullied, threatened, harassed, humiliated, and filed lawsuits against people who, for lack of a better phrase, stand in the way of whatever it is she wants to do. Judge, this defendant also has access to a considerable amount of cash. The business that the defendant ran, the treatments that she was providing were not covered by insurance. And what that means, Judge, is all of the clients of this business had to pay in cash, I mean cash or check. And this is a significant amount of money that this defendant has access to. One of the number of LLCs that her name is attached to boasts about raising hundreds of thousands of dollars in pursuit of, I quite frankly am not sure what. But my concern, Judge, is that this defendant has access, as I said, to a considerable sum of money. She is part owner or linked to a number of different corporations. Quite frankly, Judge, her husband is a forensic accountant, which means they have the means to move and conceal some of this money. And Judge, if I can land this plane, I bring all this up because what is clear in our investigation is that this defendant not only has the means and the ability to leave the state and to leave this country, but she has shown time after time that she has no problem attempting to impede the investigation into her. And quite frankly, Judge, there is no better way to stop an investigation into Tamela Peterson than by her not being here. So that's something that the people would strongly ask this court to consider in setting bond conditions in this case. I also agree that if the court is inclined to allow the defendant to be released, again, passport needs to be surrendered immediately. The defendant cannot leave the state without express permission of the court, and obviously any other conditions the court sees fit.
Great. Would you like to say anything as it relates to dangerousness that she poses to the public as a result of the investigation?
Well, Judge, again, I think, again, this is because this is a gross negligence kinds of case. It's not that it's the nature of the business that the defendant continues to run to this day. That is the threat that people are concerned about first and foremost. So the people want this defendant to have no ability to conduct any business or certainly conduct any oversight as it relates to the other Oxford Center location in Brighton. So yes, the people are concerned that she does pose a continuing threat by the nature of the work that she does and the manner in which she does it, I should say.
Right, and in the swear to, I don't know if Detective Trigger, are you going to speak today?
The prosecution.
Okay, in the swear to, I did take some notes from Detective Trigger's swear to, and in that I learned information such as the actual hyperbaric chamber that this young boy died in was past 20,000 cycles. few years ago. Would you like to speak to that?
Judge, I don't want to get too much into the facts of the case. Obviously, I think the appropriate time for a lot of that to come out is at the exam. But yes, our investigation has led us to the conclusion that one of the co-defendants in this case was actively tampering with this particular hyperbaric chamber, and all of the evidence leads us to the conclusion that it was done with the permission and perhaps at the order of this defendant.
And what, if anything, would you like to say as it relates to, I did also take notes regarding lack of safety protocols, including grounding wires. Yeah,
Judge, I think it goes, I shouldn't say it goes without saying, but, Judge, the people's position is that this was a very easily preventable situation had the defendant, and again, this defendant as the owner and the boss, for lack of a better word, of these facilities, this could have been prevented so easily if they only would have followed the manufacturer's guidelines, if they would have followed what is considered basic safety precautions. That in and of itself gives the people concern. But again, as the court already noted, not only were they not taking precautions, they were affirmatively making things more dangerous by altering the equipment so as it would look as though it was newer than it was. And in fact, one of the things that the people turned up in their investigation is that in the most recent, evaluation of this particular chamber, the number of cycles was less than had been previously recorded. So obviously, Judge, there's, it's very clear what's going on here. And as I said, the people have spoken to a number of witnesses who can and will testify to that fact.
All right, thank you. Mr. Gleason?
Yeah, I'd like to return to the court rule because there are certain factors there, and I think pretrial services started there, and that's where I think we should stay. I appreciate Mr. Kessel's argument, but I want to focus the court there. First of all, with these proffer about threatening people or wiping discs, there's no obstruction of justice charged here. There's no, and if that had occurred, we'd see a count for obstruction of justice. We don't have it. So I think that discounts the argument that's being made there. And certainly a no contact provision will certainly protect any issues there. So no obstruction. I'm going to say that that's something that we'll see in court. It's not here. With respect to the passport, I have it here for the court. And with respect to applying for a visa to China, it's in the passport. It's dated August of 2024. The purpose of the visa, Ms. Peterson's son got married in China. He's married to a person who immigrated from China, and there were relatives there. That was the purpose of the trip. This was not done recently. It was not done after the incident in question. So that, again, and that's right here. The court can look at it if you want to. It's right on there. With respect to the court rules, I did hear and I agree with pretrial services. She has no prior criminal record. She has no record of flight. She's always appeared. Now, and I want to be clear about this. 2 weeks ago, I told the Detroit Police Department, if charges come, we'll appear voluntarily. No need to go arrest her. We'll present her to the court. We'll present her to the police department. Apparently, that wasn't good enough for the Detroit Police Department, and I respect the detectives. But all they had to do was call me, and we'd be standing here voluntarily. Instead, we're in a box being recorded by the media. And I take issue with that, and I've raised that with the Attorney General's office already. We would have appeared voluntarily, just like I voluntarily brought the passport today. Likewise, if there was flight here, I don't.
Mr. Attorney, you're doing a great job defending your client, but if you, there's a few things here out of order. If everything, if your client was serious about, hey, if there are charges brought, the passport should have been with you when you went and talked to the district attorney's office. Now you brought it to court after the arrest, after they found out about a visa, after they found out she, for some reason, had Iraqi currency. This is strange.
If the court signed the warrant or another magistrate, but it was signed on March 4th. They waited to the 7th to arrest her. If there was a flight issue here, they would have gotten her the same day. Likewise, Your Honor, with respect to the rule, there's no history of substance abuse, no history of mental health issues. And while the crime of second-degree murder is a serious offense, it carries a number of different mental states. And as the Attorney General stated, there was no violent act here. This isn't the type of second-degree murder that involves a shooting or strangulation or other type of violent act. And likewise, there are 3 different states of mind for second-degree murder: the intent to kill, the intent to do great bodily harm, and knowingly creating a high risk of great bodily harm, knowing that death would result. And I don't think you did the swear to, I wasn't here, but I don't think an allegation is made that she intended to kill anybody or intended to do great bodily harm. And with respect to that third mental...
That's not the entirety of it. Then you have to go into case law regarding this. I have to check with Dave because this is out of Michigan. So, Dave! I have to check the provisions regarding that. Let me send off a DM to Dave. All right, let's see if he sees my message so he can explain it better. Because Dave, who is regularly here, is an attorney in Michigan. He is a criminal defense attorney, so he should be able to get... we should get good information from him.
State, the court should be aware that both of her parents utilize these hyperbaric chambers regularly. And I think that tends to discount the idea that she was somehow operating these with reckless abandon when putting her own family members in that. That's
she's
for
a
another day.
sociopath.
I recognize that's a preliminary examination issue. It's been raised today. I'm simply responding to it. Your Honor, with respect to what we have to do to assure the protection of the public, this is not a woman who's going to go out and do further violence. Those hyperbaric chambers, obviously, in Troy, that facility has been closed. The ones in Brighton have not been utilized since this happened. They are going to continue not to be utilized. And I, on her behalf, and I can state to you, if you order it, they will continue not to be used. They're not in use and will not be in use going forward. So the protection of the public, as outlined by the Attorney General, has already been solved, has already been prepared. Now, if the court wishes to have some amount of cash to have her show up, I am not hearing a number from the Attorney General. I am hearing a personal bond from pretrial services. And I recognize what the facts of this case involve. It's a tragic situation. A child has died. There are parents in this courtroom. I'm a parent. I understand that. But in this particular case, this woman does not present a risk of flight. And under the circumstances that we've established at the Brighton facility, there's no risk of danger either. If the court has questions, I'm willing to answer them. But certainly a high bond is not necessary to meet the goals of the court rule here.
Thank you. Next. The purpose of bond is not to punish, it's to ensure protection of the public and your reappearance in court. This is a very serious case. It involves the death of a young child. It involves the death of a young child in a horrific way. And I'm not going to use the term tragic because I think a lot of what we're looking at was disregard of safety protocols that created the risk of this happening. And that's exactly why we're here today. Had a grounding line been employed, had the tally for how many cycles of this chamber not been altered, it read less than it did in 2022, this child would be alive today. So in my mind, that is an individual that runs a business entity with the goal of making money and throwing safety and caution to the wind. I have heard that she had wiped her laptop. That I also heard from the detective when they were trying to obtain a cell phone. I don't know if that was in a parking lot or where it was. She actually ran from the investigators. I also heard from the detective that there were statements. I really am hastened to get too deep into this because if there's anyone in the courtroom, I don't want to upset them. But I will state that I believe there was inappropriate use of still photographs taken from the CCTV of this incident. And comments made regarding that. There's also information regarding a previous Attorney General investigation that your office handled that involved an individual lying essentially about accreditation to work in the facility.
Judge, I mean, that wasn't raised here. I haven't had a chance to respond.
Well, he can raise it if you'd like to state it.
Well, Judge, I think, and actually the prior investigation that I was referring to isn't even that investigation. It's another investigation involving healthcare fraud allegations. So that is the people's overarching concern, is it is very clear that this defendant, and thank you for reminding me, Judge, and Detective Trigger told me that this defendant literally, when it was made clear her phone was to be examined, she grabbed it and ran. So the people's overarching concern is that this defendant has a well-documented history of attempting to impede law enforcement, and her lack of appearance would be, you know, the cherry on the sundae, if you will, of impeding the investigation to the best of her nature.
So in order to maintain the integrity of the judicial proceeding, I have to ensure that she's not going to continue in behavior that's alleged, that she will appear in court as directed. But what I can't get beyond is an individual whom the allegation suggests would put a person at risk of harm by simply not adhering to standard safety protocols and tampering with the reading of this particular chamber. The very nature of the hyperbaric chamber is higher levels of oxygen, highly combustible, risky, dangerous. Should really be handled with the utmost care and concern and respect. The history of Ms. Peterson troubles me as it relates to impeding investigations. This case is of great concern for public safety. If this is how this operation is being run, I'm so relieved that no, this hasn't happened before. I'm horrified for the family, and I'm not going to call it tragic because, again, I don't think that's the correct term. I think this was foreseeable. Tragedy implies something that's not. She does have access. I will take the passport. We will take that prior to any posting of bond. That will have to be submitted to the police department for safekeeping. She does have essentially a cash business. She has the ability to, she has the means to leave. She has the ability to circumvent this investigation based on her history, the best predictor of future behaviors past. But what I'm going to do at this point in time is set her bond in the amount of $2 million with the following conditions. She'll be under the supervision of pretrial services. She will have no contact with Alita Moffett, Gary Markin, or Jeffrey Mosfeller. She will not return to the Oxford Center, neither virtually or in person, the Troy location or the Brighton location. She shall submit her passport prior to release. She will be affixed with a GPS tether, steel cuff prior to release with home confinement and restricted leave. No contact with any current or past employee, officer, service provider, or maintenance entity which has had any contact with the hyperbaric chamber in question. Do not leave the state of Michigan without permission of the court. Personally appear for all court proceedings. No new criminal offenses or activity. And immediately notify the court in writing of any address, phone number, or email changes. No corporation or business entity of which defendant is, was an owner, officer, or director of care, past or present, shall operate a hyperbaric chamber in the state of Michigan. The Oxford Centers shall cease all operations related to hyperbaric chambers.
Your Honor, if I may.
One moment.
Yes, ma'am.
Furthermore, she is not to possess any firearms or weapons, and they shall be turned into the arresting agency and provide proof to the court at 52-4 bond compliance at OCOG.com within 24 hours. Mr. Dixon.
The court consider a 10% revision. That's a very substantial amount.
The bond that I set is actually lower than I anticipated.
Oh,
You're the judge.
Thank you.
okay. So, 2 million bond. He asked for a 10% provision. I didn't hear her say okay to that. Huh.
They're going to take her out.
Okay, so that was her arraignment. The CEO of this company who, for some reason, a hyperbaric chamber for the kids' ADD and some other things, which I've never heard of, how that is even remotely going to help. Yeah. I've never heard of this treatment. So it seems like a snake oil facility for parents and people who are desperate because nothing else works. Let's try this. ADD and sleep apnea. Okay. Yeah, sleep apnea. That I can see. Because sleep apnea, that is people stop breathing in their sleep. Interesting. And it is very weird with the visa to China, not that weird. A lot of people have it. The currency things, that's weird. And she runs a cash business. She has 2 facilities in Michigan and then facilities in other states. This is a multi-million-dollar operation she runs. So, yeah. Strange. Let's see how the rest of this goes. Next one.
Like 25-000875 FY. People of the state of Michigan versus Gary Markin. Chris, the record.
No, Chris Kessel,
How are we proceeding with the arraignment?
And at this time, my client would waive the formal reading. My client would also stand mute to the charges.
All right, thank you. Indicating a waiver of the formal reading, a plea of mute to the charges will enter on your behalf, sir. You do have the right to be represented by an attorney. You sought out hired your attorney of record and been unable to do so, and upon request would have been considered for the appointment of an attorney. Furthermore, as you are charged with felony offenses, you do have the right to a probable cause conference within 14 days. You also have the right to preliminary examination within 21 days. That is a hearing in which the prosecutor bears the burden of proof to establish by probable cause the crime was committed and probable cause that you committed it. The examination date is March 19th, 2025 at 2:30.
Exam, Your Honor, or probable cause?
Excuse me, probable cause.
Yes, Your Honor.
Thank you. And the examination date is March 26th, 2025. Answer, I should also indicate to you that you do have the right to remain silent. Anything you say orally in writing can be used against you in court. So I have indicated the waiver of the plea, enter pleas of mute to the charges. Next issue is bond. Ms. Rogers?
Your Honor, Brenda Rogers, pretrial services. I did interview the defendant. I was not able to verify his information. He did provide his wife, but did not have a phone number for her. He reports he's 65 years old, born in Michigan. He's been married for 41 years. He has 3 adult children. currently living with his wife in Spring Arbor, reports living in Jackson County for the past 6 years, working full-time at the Oxford Center as a director of facilities at the Brighton location. He states he's been there for 16 years. Regards to alcohol, marijuana, or any drug use, he denies all use. Reports he's in good physical and mental health. The defendant has no prior criminal history on record. However, there is great concerns regarding allegations and the possibility of penalties if convicted. The defendant does have gainful employment of 16 years. He has stable residence. He has no prior criminal history, no outstanding warrants, no pending matters, and no history of failing to appear. Therefore, release on personal recognizance is being recommended. Pretrial services does have concerns for the public safety related to the continued operations of the Oxford Center. For those reasons, the following conditions are being recommended: not to return to the Oxford Center virtually or in person, have no contact with the co-defendants in this matter, must surrender passport to the court within 24 hours of release, be supervised by pretrial services supervision, no possession of a firearm or dangerous weapon, and no contact with the family of the listed victim.
Would you please name any as condition?
Derek says got put on 100% oxygen when he had double pneumonia. Yeah, see if I have it still here. Yeah. For you who have followed my channel for a bit, you know that I was out of commission for a while. And that is because I was walking around with this in my nose, double pneumonia. And that was back in February. And my lungs are still not 100%. So yeah, the older you get, the more dangerous pneumonia gets. So be careful, folks. Be careful. All right, let's go.
Your client is still no contact with the family of the listed victim.
Yes, sir.
All right, thank you. Counsel.
Thank you, Judge. Again, I think we don't need to go over some of the specifics regarding the seriousness of the case. I will say that people outside of the general concern about flight in a case this serious, we don't share the same concern about flight with respect to this defendant as we did with Ms. Peterson, for the reasons that we stated on the court, to the court. But again, we are greatly concerned, as we talked about with respect to Ms. Peterson, that this defendant was personally involved in altering these machines in a way that made them seem like they were safer than they were, made them seem that way to the manufacturer, made them seem that way to the patients. And again, in this case, it was this one specific machine that multiple witnesses have identified that this defendant was working on, rolling back those numbers. In essence, I hesitate to use this phrase, Judge, but I don't know one that's more applicable. He was literally making this a ticking time bomb. That's what his actions were doing. So the people are very concerned about that as it relates to bond. Otherwise, I think the rest of the factors have been addressed with respect to Ms. Peterson, so I don't have anything additional. Actually, other than to say, and I suspect the court is leaning this way, that this defendant, as part of his bond condition, should have nothing to do with the Oxford Center or any other hyperbaric oxygen treatment facilities or treatments or anything of that nature.
Thank you. Counsel.
Thank you, Your Honor. Your Honor, first and foremost, we do recognize the seriousness of the charges. At Attorney General Nessel's press conference a couple hours ago, she indicated these are merely charges and the accused is presumed innocent. And I want to keep that in the court's mind, that he's presumed innocent. I will tell you that Mr. Markin has not been to the Oxford Troy facility in over 3 years. I don't know where the information is coming from that he is rolling back any of these things, but I can tell you that we're confident he hasn't been to that facility because he worked at the Brighton facility. However, Your Honor, with respect to protection of the public, there's no concern that he's going to do anything at this point in time to endanger the public or do anything that would cause the court concern to the public. He didn't operate these machines, Your Honor. He was a facilities manager, and I'm sure that's going to come out at the time of the preliminary exam. Your Honor, with respect to previous criminal history, none. 65 years old, married 41 years. His entire family is in this courtroom. They support him. He was on salary. He was not making a huge amount of money at this corporation. He does not have ties to any other countries. He doesn't have any major assets to give to the court. But I will tell you the most important thing that the court should know and take into consideration is that we were offered an opportunity to sit down with the authorities, and we agreed to sit down with the authorities with the understanding that we could bring this man in when the charges came due. He sat down with the authorities, explained his role, explained his involvement in this, gave his passcode to his phone, and we were under the impression that we would be able to bring him in today walking him in as opposed to him in handcuffs. Your Honor, I think that goes a long way towards your recommendation for bond. If this guy's willing to sit down with the authorities and give his side of the story freely and voluntarily, then you have to take that into consideration. And I know Sergeant Flood's in the courtroom, and he would be nodding his head right now and saying, yes, that's correct. He did sit down. He did agree. Others may or may not have done that, but we did, Your Honor. Your Honor, he's cooperated again with the police. He is battling skin cancer. He is scheduled for surgery April 1st. I think the court should take that into consideration. I think that makes sense. He's led a full life of law-abiding. Now, I don't know what proofs they're going to be able to show with respect to rolling back these tickers or these things, but I think that they've got a heavy burden to show that he knowingly did this and that he knowingly knew there was a risk of harm, of death in a case like this. Your Honor, with respect to probability of appearance, he lives here in Michigan. He's lived in Michigan all his life. There is no reason for him to leave. Again, I bring up the fact that why would he sit down with the authorities and discuss the case with them when they were in need of information that he provided? Your Honor, I think the recommendation for a high bond wouldn't, if there's a recommendation for a high bond, I would disagree with it. I think pretrial service is correct. A personal bond makes sense. You can achieve all these goals by giving him a personal bond with conditions like a GPS tether. If you want to keep track of him, that's fine. A GPS tether makes sense. There was no reason that he would flee. There's no reason that he would leave the jurisdiction. I'm asking the court to allow us to really represent him instead of representing him behind bars. I'm assuming there's going to be volumes of discovery in this case, Judge. And as you know, dealing with the jail, going back there with computers and videos that we're going to have to look at is going to make this case 10 times harder. I'm asking you to consider a personal bond. I'm asking you to consider, if you are not inclined to do that, some sort of a 10% bond that is reasonable in this case. And again, I have to make a big deal about the fact that when he was asked by the police, will you sit down and cooperate with us? He said, yes, and he did. So, Your Honor, I would ask the court to take that into consideration, take into consideration the health, the issues that we've got to deal with, that he's got surgery scheduled for April 1st, and impose a reasonable bond with conditions as you see fit, Your Honor. Thank you.
Mr. Markin, have you stated your name for record, or previously stated? Thank you. Sergeant, would you like to respond to anything that counsel brought up?
Sergeant Flood is.
Oh, Sergeant Flood? Yes, would you like to reply to any of that?
Oh, counsel says.
Okay, thank you. All right,
Okay.
so again, focus upon
Yeah. Okay. So apparently he is fully cooperating with the authorities.
twofold is to ensure your appearance in court as well as protection of the public. This case, by the very nature of the allegations, a hyperbaric chamber with high saturations of oxygen is essentially a ticking time bomb. If that unit is tampered with, it becomes Russian roulette for whoever gets into that chamber. This was a 5-year-old boy. His life is gone. His mother essentially did what all parents would say: I would walk through fire for you. My understanding is she put her arms into fire to try to save her son. I cannot risk that happening to any other human being on the face of the planet Earth. That is such a torturous, horrific, heinous image. I have to ensure that you never have the ability to come near, I'm not saying never, I'm saying while you're on my time, not come near any sort of facility that participates in the treatment using hyperbaric chambers. I also, going back to my understanding of his involvement with Ms. Peterson, is that they basically were hand in glove. They shared an office at the Brighton location. If he were to be the person that were doing her bidding, turning these things back, obviously that's a very dangerous person in my purview. The charges are substantial, they're severe. We're dealing with a murder 2 charge, in addition to the involuntary. I need to ensure his presence in court. I need to ensure the protection of the public, and I'm setting bond in that regard to do so. I am setting bond at $250,000, cash surety with no 10%, pretrial services supervision. No possessing any firearms or weapons, third to the arresting agency and provide proof to the court if you for bond compliance bill from that time within 24 hours. No contact, Tamela, Peterson.
That's a substantial bond.
Do not return to the Oxford centers in Brighton or Troy, virtually or in person.
Thank
There will
you.
be a GPS
Thank you,
cover
Ro.
prior to release, passport turned in prior to release to the police department with home confinement, restricted leave, attorney, medical, in court.
Yeah, I mean, $250,000, no 10%. So we have to cough up $250,000. That's, I understand. For the type of charge, it's low. I've seen much lower, especially people who cooperate with the authorities. But at least it's manageable for him. And thank you to Jerome, who sent a super sticker with a pear who says, "Keep it up." And I will, Jerome. You know I will.
In addition to verified employment, I don't know what that will entail. Shall not seek employment with any entity that provides hyperbaric chamber treatments. Do not leave the state of Michigan without permission of the court. Personally appear for all court proceedings. No new criminal offenses or activity. Immediately notify the court in writing of any address, phone number, or email changes. No contact with any current or past employee, director, officer, service provider, or maintenance entity which has had contact with the hyperbaric chambers at the Oxford Center. Any questions? All right, you can see this, right?
Thanks, Your Honor.
Line 25-000878FY, people of the state of Michigan versus Jeffrey Allen Mosteller. Peterson for the record, please.
Thank you. Good afternoon again, Your Honor. Assistant Attorney General Chris Kessel for the people.
Michael Dick on behalf of Mr. Mosteller.
Mr. Mosteller, would you state your full name for the record?
Jeffrey Allen Mosteller.
Thank you. How are we proceeding in this arraignment?
At this time, my client would like to waive formal reading and stand mute.
Mr. Mosteller, indicating a waiver of the formal reading of the charges, please, if not guilty, will enter on your behalf. You do have the right to a probable cause conference within 14 days. There is a schedule for March 19, 2025 at 2:30 p.m. before Judge McGinnis. For the PCC, you also have the right to a preliminary examination within 21 days of the hearing with the prosecutor as established by probable cause that a crime was committed and probable cause that you committed it. And that is set for March 26, 2025 at 9 a.m. You also have the right to remain silent. Anything you say orally or in writing can be used against you. You also have the right to be represented by an attorney. Is he requesting appointment of counsel?
I believe he indicated that he believes he might have retained, but I'm not certain at this point. We did fill out a request for attorney form, Your Honor.
All right, sir, so you've got a few options. You can hire your own attorney, which may take some time. I don't know what your financial situation is. Or you can petition the court for the appointment of an attorney, and that would be appointed by the MIDC, and they would determine whether or not you're eligible. Or, of course, that option is to represent yourself.
Then I'll go for the court one.
Okay, so at this point in time, I will review your petition for the appointed counsel. If you are able to secure retained counsel, we ask that you do contact the court so that we can call off an appointed attorney. All right, sir?
Your Honor, not to interrupt your review, but this does include employment at the Oxford Brighton location. So any income, if that were going to be.
Okay.
Yeah,
Based on the information.
I mean, I've never heard of a hyperbaric chamber in treatment for sleep apnea, ADHD, but there will always be people who profit out of desperation. There is always going to be those people. Old Wild West snake oil handlers. I mean, you have more egregious. You have for instance, when my mother got ill in cancer, she got ill when we were, all the kids were small. This was way back when the treatments were horrific. And when she eventually got more or less we can't do anything more, then she went off to these experimental things. Algae treatment, anything. And there are people out there who will profit out of desperation. And this seems to be one of these cases.
That's been provided, taking out any income from the Oxford Center, and you find that you qualify for the appointment of an attorney. So one will be, I will send this up to the appointing authority to have an attorney to represent you. Does your phone number end 6719? All right, thank you. The next issue is bond, purpose of which is to ensure your presence in court and for protection of the public. Ms. Rogers.
Ms. Senator Brenda Rogers, pretrial services. I did interview the defendant. The report was completed by investigator Heather Golan. She was able to verify the defendant's personal information with his girlfriend, Tamela. The defendant is 64 years old, born in Georgia. He is divorced since 2016. He has no children. Reports living in Clinton Township with his life partner Tamela since 2019. He does report full-time employment at the Oxford Center in Brighton, Michigan as a safety director and educator. He states he's been there since July of 2019. He does report he's obtained an associate's degree in underwater technology. He denies any use of alcohol, marijuana, or illegal drugs. No history of substance abuse was reported. He states he's in good physical and mental health. He reports that he was arrested on this offense during a traffic stop in Clinton Township on yesterday's date. Defendant has no prior criminal history on record, no outstanding warrants or hold, or history of failing to appear, no pending matters. While there is great concern regarding the allegations and possible penalties if convicted, there is no reason to suggest that he's a threat to the community at large or a flight risk, given his stable residence and employment. Also, given the concerns for public safety, pretrial services have concerns regarding the continued operations at the Oxford Center. For that reason, we are recommending the defendant not return to the Oxford Center either virtually or in person. He be released on personal recognizance, supervised by pretrial services supervision, no possession of a firearm or dangerous weapon, no contact with the listed co-defendants or the family of the listed victim, not to return to any Oxford Center, must surrender his passport to the court within 24 hours of release.
Oh, thank you. Your Honor, again, as with respect to Mr. Markin, this defendant, we don't need to, sorry, we don't need to repeat, the seriousness of the offense. Again, there is not any specific concern with this defendant as it relates to flight outside of the serious nature potential penalties in this case. This defendant was the, for lack of a better phrase, safety officer at the Oxford Center, which is something considering the way that this facility is being operated. As the court is aware, multiple safeguards were being disregarded knowingly. The investigation showed that this defendant was conducting his own experiments to try and prove the safety as it relates to this particular chamber. Just obviously these were his own experiments, none of which were actually recognized by any sort of scientific body. They were not peer reviewed. And people were trying to hide the actual safeguards that were being disregarded, that these experiments were meant to show the under employees that what they were doing was safe because look at these
It's in Michigan.
So that, again, Mr. Markin, that is the people's concern that this defendant have no contact with and have nothing to do with any sort of hyperbaric oxygen treatment.
Troy, Michigan.
Any other
Troy, Michigan.
Oxygen as well. I would ask the court to incorporate those into the bond.
Your Honor, we are asking for a reasonable bond. My client has no prior criminal charges or convictions, no prior failure to appear. I have no doubt that if he were made aware of the charges, he would have appeared in court today on his own volition rather than being pulled over in a traffic stop in which there were no new pending charges or tickets issued. I believe he was just stopped like many of the other defendants here in order to be picked up at the same time. A lot of the safety concerns, I believe, can be adequately addressed through the terms of his bond. Though through any specific ones that were just mentioned, I don't feel confident directly speaking to those as I'm not going to be his counsel moving forward. So I don't want to speak to any specific allegations. But other than his clean record, we would ask for a reasonable bond in this place, Your Honor.
All right, once again, purpose of bond twofold: ensure your presence in court, protection of the public. As a safety director, the allegations suggest that you were at the fail stop, taking direction reportedly from someone above you as how to run this facility. And what the prosecutors just indicated to me is frightening, that safeguards were not utilized, experiments were done to show employees, lead them down a wrong path, that things were safe when obviously they were not. Not tragically, damages that were, this could have been prevented if proper protocols were followed. I can't get over that form of judgment was utilized. And if that's the form of judgment that you're utilizing in your life, I have some concerns about you and your ability to participate in the criminal process going forward. I don't know what other judgment calls you would make in terms of would you not come back to court. This case is too serious. It must be brought before the court system. For those reasons, and incorporating by reference other statements previously made on the record, I am setting your bond at $250,000, cash surety, no 10%, pretrial services supervision. No possessing any firearms, turning to the arresting agency and provide proof to the court at 52-4 bond compliance, go.com within 24 hours. No contact with Tamela, Peterson, Gary Markin, Alita Moffett. No contact with the family of the listed victim. Do not return to the Oxford centers, either Troy or Brighton, virtually or in person. GPS tether prior to release, steel cuff, restricted leave, home confinement, attorney, medical, and court, and verified employment. You shall not seek employment with any entity that provides hyperbaric chamber treatment or the use of oxygen. Passport to be turned in prior to release to the police department. Do not leave the state of Michigan without permission of the court. Personally appear for all court proceedings. No new criminal offenses or activity, and immediately notify the court in writing of any address, phone number, and/or email changes. And I haven't confirmed any of these defendants' addresses on the record for a purpose, and that's because everything's being recorded, and I'm not trying to turn everyone's address to the public. But we will need to confirm that prior to everyone departing today. No contact with any current or past employee, director, officer, or service provider, or maintenance entity which has had any contact with hyperbaric chambers at the Oxford Center. Any questions, sir, regarding your non-maintenance conditions? Have a seat, sir.
Thank you, Your Honor.
Or actually, you can go with the officer.
Hi, Derek. They still haven't heard what or how caused the spark. Now, this is just arraignment. So next person will also have it's just arraignment, but I have here a court hearing from 2 weeks ago. So that we will go right into that part.
Using the same mailing address that we have for you on the court file.
Yes.
Thank you. You can be seated. Today is the date and time that we have scheduled the state's motion. This was a motion that was filed previously entitled Motion for Court Approval of Review Team Process. I did have an opportunity to review a response that was timely filed by the defense. And in addition, after the last court date, the people were able to provide Exhibit A, which had not been attached to the original motion, but the court found it quite necessary to include it. So we received that shortly after the last time we were together for court, and I've had a chance to review that as well. I know that because that was filed after the fact, the defense was provided an opportunity if they wanted to supplement their.
Oh, we have a even earlier one here with the safety manager. Other than that, it's just the arraignment. Dun, dun, dun. No, here it is. I think. Yeah, this one. Sorry. Going to this.
2500875. This is the state of Michigan versus Gary Markin. Attorneys, place your appearances on the record.
Thank you. Good morning, Your Honor. Assistant Attorney General Chris Kessel for the people.
Good morning, Your Honor. Todd Flood on behalf of Mr. Markin, who is to my lower left corner. Mr. Markin, if you could just place your name on the record.
Gary Markin, present.
Thank you. Mr. Markin, are you still using the same mailing address that I have for you, sir, in Spring Arbor?
This is from 2 months
Yes.
ago.
And are you consenting to appear remotely today using Zoom for your probable cause conference and motion?
Yes, yes, I am.
All right, moving on to 5000876, people of the state of Michigan versus Tamela Peterson.
Thank you. Good morning, Your Honor. Assistant Attorney General Chris Kessel for the people.
Gerald Gleason, and behind me, Thomas Kramer on behalf of Ms. Peterson, who's appearing by Zoom from her home, and we do consent to the Zoom process.
The $2 million.
Thank you, Ms. Peterson. State your name for the record.
So she posted a $2 million bond. Okay.
Yes.
All right, thank you. Moving along to the next case, 2500878, people of the state of Michigan versus Jeffrey Allen Mosteller.
Thank you. Good morning, Your Honor. Assistant Attorney General Chris Kessel for the people.
Good morning, Your Honor. Alona Sharon on behalf of Mr. Mosteller, who is obviously seated to my left in my office, Your Honor, and we have no objection to proceeding by Zoom today.
Thank you.
Yeah. Okay. So I'm showing this so we can get as early in, so we can get in on the earliest possible hearings, where we can hear some of the evidence, some of the charges, and eventually some of the motions being brought by either side. So there's one 2 months ago, and then there's one 2 weeks ago. I will definitely check this one out. Then I might save the next one for tomorrow, Saturday.
And your client state his full name for the record.
Yes, Jeffrey Allen Mosteller.
Thank you, sir. You're still using your mailing address in Clinton Township?
Yes, Your Honor.
All right, thank you. And then I have 2500877, people of the state of Michigan versus Alida Howard Moffitt.
And thank you one more time, Judge. Assistant Attorney General Chris Kessel for the people.
Good morning, Ellen Michaels on behalf of Alida Moffitt, who is present over Zoom, and we agree to proceed over Zoom for today's probable cause conference.
Thank you, Ms. Moffitt. Please state your full name for the record.
Alida Howard Moffitt.
Thank you. And you're still using your mailing address in Rochester Hills, ma'am?
Yes.
All right, thank you. Today is the date and time for adjourned probable cause conferences for all 4 defendants. I also have a motion that I will be addressing separately as it relates to Mr. Flood's client. But let's begin with the probable cause conference. This was an adjourned date. We were together originally for a probable cause conference on March 19th of this year. At that time, all of the parties here were apprised of their right to have their exam begin within a certain and specific time frame. They waived that right so that additional time could be provided for them to work with their attorneys, obtain and review discovery, and make a decision about proceeding to an examination. I'm not sure if you're all on the same page as to where you're at this time, but I would like to hear from each attorney on behalf of their client as to how they're proceeding.
As it relates to Mr. Markin, Your Honor, we're proceeding to a preliminary exam. We just need to schedule a date.
Okay.
That's,
Your Honor, as a- oh, sorry.
go ahead, Ms. Sharon. Sure, I can wait.
Okay. As to Mr. Mosteller, Your Honor, we also intend to conduct the preliminary exam. However, we would be seeking a date that is sometime after the inspection that was tentatively scheduled for May 7th, but late last week, it was either Thursday or Friday, Your Honor, it appears the civil attorneys could not get certain things resolved, and so they've pulled that May 7th date, and there's now a list of possible dates in June that's being floated around, but no date has been settled upon. I have at least one expert who will be present for that inspection, so I would ask that the prelim, at least for Mr. Mosteller, not proceed until after that inspection.
All right, Ms. Michaels, I'll let you go next just for everybody's knowledge. We were not going to be conducting a preliminary examination in this case before May 7th, so that wouldn't be an issue, but obviously we will look to see if others have additional information or requests about the scheduling. So I think actually Mr. Gleason was next on behalf of Ms. Peterson. What would you like to say?
Your Honor, I'll echo what Ms. Sharon said. We would like to be present for purposes of that inspection. Julie Dufresne, the city attorney, who I know the court is familiar with, is representing the city with respect to the fire marshal's availability. If I'm reading the emails correctly, the cause and origin determination has not officially been completed, and that is why the fire marshal's attendance is required, and I think it's his schedule that is also at issue between the lawyers for the civil plaintiff and defendants. And I think there may be more lawyers on that case than there are on this one. So Ms. Sharon was correct that they're looking into June for that examination. I don't know what Mr. Kessel's position is, but I would assume he would want the cause and origin examination done before a preliminary examination. I would have thought perhaps before issuing charges, but I will defer to him in that regard. So what I suggest to the court would be that we await that examination and determination. I believe the fire codes and ordinances, et cetera, that govern this require the opportunity for all of the parties to be present to conduct it at the same time. And I think everyone having waived the 21-day rule, that would be in everyone's best interest.
All right, and Ms. Michaels.
Thank you so much. Good morning again. We concur with Attorney Sharon and Attorney Gleason that the inspection is crucial to the defense in this case, and we are asking to push out another PCC date so that we can be sure that the inspection takes place sometime in June, and then we can schedule an exam at that time. It is very important to the defense to have the inspection occur prior to the preliminary exam for all the reasons already stated.
So what kind of explanations were you getting for the date that you had thought was going to be utilized for the inspection not working at this point? I'm interested.
The May 7th date. Oh, sorry. The May 7th date was canceled because the TRO. There's a temporary restraining order making the site that the parties can't get into the site. So the private attorneys, the civil attorneys, need to come together and go before the civil judge to have the TRO amended to allow them access to the site to do the inspection. That hasn't happened yet for a variety of reasons. So once that happens, that the TRO is amended to allow access to the site, a date can be confirmed.
Your Honor, if I may, I also think part of the delay or part of the problem was that they needed to all agree to some set of protocols for the investigation. And I know that was only circulated last week, maybe on Wednesday or Thursday. And again, we're all copied on these emails, but it's really a conversation more that the civil attorneys are having. And if we want to be part of the inspection and have an expert there, we're being apprised of the dates moving forward so that our experts can be included as well. I can tell the court that for the most recent list of possible dates for the inspection, the earliest of which on the list is June 4th, the latest of which is, I think it was June 26th, Your Honor, if I'm not mistaken.
It was.
Yeah, June 4th. And then there's about a list of 8 or 9 possible dates, and the latest of which is June 26th. So I think we're all hopeful that it will happen in June, but it's really just a matter of the civil attorneys agreeing, I think, to the protocol and then getting, as Ms. Michael said, the TRO lifted.
And can you remind me, who is the judge that's presiding over that case?
Judge Brennan.
I need to go fetch more beer. Hold on.
Judge, if I understand it correctly, there's not a lawsuit in place. There's just a temporary restraining order. So the vehicle they used to hold this up for the criminal proceedings to be basically truncated, or however you want to put it, is this TRO, this restraining order, which is kind of, I don't know, seems a little bit backwards because there isn't a suit in place. The Attorney General's office should have the power for us, the criminal lawyers, to make sure that we get in and have the, as Mr. Gleason said, the cause and origin of this incident. The fact of the matter is that we have a lot of experts. All the attorneys in this forum have an expert, all waiting to see, and including that of the fire marshal, waiting to inspect this. So I don't know if the court can call the circuit court judge to see if we can somewhat make this happen. I mean, this case could go on for a long time if we can't get a preliminary exam off the ground just because of an inspection.
So I think it is somewhat of an unusual set of circumstances. I'm also getting a sense that whatever protocols these civil attorneys decide would be appropriate for their needs are going to apply to the four of you without the ability to weigh in. I don't know if that's something that seems like the likely outcome based on the emails that you've been able to review, but not necessarily participate in. Does anyone have an objection to that, or are you comfortable with whatever protocols are arranged in that case? They will be permissible for you to get in and get the information that you need.
think it all has to happen at once. I don't want an expert without my expert there. I don't want someone, I can't imagine anyone would want to have an inspection of this or tampering with this or manipulating the material to figure out cause and origin without my expert or any one of us. Jerry's expert, Alana's expert, Ellen's expert. We'd all want to have our experts there. So I can't imagine the civil attorneys trumping us, the criminal side, that, we should be able to do this all at once. I think there should be an order in place, some sort, to make sure that happens.
But are you feeling as though you have an ability to negotiate what is going into a protocol that would be presented to the circuit court judge? That's my question. I don't know if you're just like an FYI, here's the conversation and this is what we'll be doing, or are you getting the emails because you have an ability to weigh in and make requests based on what you believe your experts will want to do?
I think we'll have some weight, Judge, but the standing is a bigger issue, right? In the circuit court, in the civil case, for us, standing is a issue. But I think Mr. Kessel and all of us could probably weigh in on making sure that happens. He has the power. The Attorney General's office has the power to make this happen.
So I guess the other issue that I am thinking that I probably should get a little bit more information on, there have been some stipulated orders that have been presented to me in this case that appear to be negotiated between either the defense attorney or the Attorney General regarding sale of assets and other things like that. Are the attorneys that are submitting the stipulated orders to this court complying with everything that may be included in that TRO, which I have not seen?
Yes,
I believe so. My recollection is the TRO is to the location itself. And obviously, as the court knows, I don't think that you can get a restraining order for assets and certainly a prejudgment attachment, if you will. So I don't think that that's even legally permissible. But in terms of the bond condition, the order that we submitted, it was solely to allow Ms. Peterson to talk to her family primarily, and then have some discussions regarding the property in terms of the sale of the remaining chambers that are not at issue in this case, and then business decisions that need to be made due to the economic conditions. But we're not. And I'll double check. To be honest, I'll double check. But I don't believe we're infringing on Judge Brennan's order at all.
Well, I would like to make sure of that. I don't have any information about what the TRO contains, if it has any other restriction as it relates to other property or assets that are at that location. And when I'm presented with a stipulated order by the Attorney General's office and in your office, Mr. Gleason, that indicates that it's permissible for certain things to be sold or discussions to be had about selling assets, I need to make sure that they strictly adhere to whatever else is in that circuit court order. So I'd like the two of you to just go back and double check, make sure that that's not an issue. And then we can proceed accordingly. But obviously that has to be in the back of our minds, I guess, as long as this order is in place.
Yeah, I mean, there's a civil case going on and a criminal case. As I'm not surprised by that. What I am surprised about is that it seems like the civil case are putting in orders that is hindering the criminal case. That's strange. This Judge Brennan should be awaiting the decisions in the criminal case before making judgments. So that is strange.
Place, even if we are a little bit confused as to how it is taking precedence right now over completing the criminal investigation so that we can proceed to an examination. So I'm hearing every attorney on behalf of their client tell me that they're going to proceed to exam. There is,
Yes.
I think, a joint request from all four that it should take place after the inspection is completed. And it appears that all four attorneys on behalf of their clients are in agreement that that process of scheduling the inspection date appears to be moving forward, but a recent delay is causing us to look ahead to June for the actual date. So if you're telling me that the date of the inspection is going to potentially be somewhere between June 4th and June 26th, I know from two of the attorneys that provided some dates they were unavailable during the summer months. I think the 26th might be cutting into some time that the attorneys might be unavailable, at least one or two. I'm not certain. I do have that information printed out. So hopefully we could look at the beginning of June where I didn't get any indication that people would be unavailable. And then after the inspection is completed, knowing that all four of you will likely be bringing your own experts, how long is it going to take your experts to get you the information that you need to consider using it for the exam?
Your Honor, could I suggest perhaps setting a probable cause conference for the first week in June? Because I would certainly assume that by then, everyone would know when the date of the inspection is going to be and have had ample time to discuss with their experts how much time their respective experts will need to prepare. I'm not sure. I think you could also set something at the very end of May. I would hope by then there'll be a date for this inspection because they've been trying to get this inspection done now, I think since shortly after all of us started representing our respective clients. So I would recommend respectfully that a probable cause conference either be set for the very end of May or the first week in June. And at that point, hopefully we all have enough information where we can settle on an exam date, if the court's agreeable.
Your Honor. We agree with that, Your Honor.
Your Honor, if I may just add on to that, I think the issue here is that the government's expert is the one we're going to want to see in terms of the testimony that Mr. Kessel's going to offer regarding cause and origin at the preliminary exam. So I think the driver here will be A, the date of the inspection, and B, the release of any report that Mr. Kessel and his expert generate, and then we and our experts can critique that and prepare cross-examination accordingly. So I think that's the drivers. Those are the two drivers.
Okay. All right. Well, I had been looking at dates in June that I was setting aside to have the exam. I don't know if that's really going to be feasible at this point. But I know that a couple of the attorneys had indicated dates that they were unavailable in July. But I definitely think that we need to continue to have the four of you work together in conjunction with all of these other people that are related to the case to get the information you need so we can schedule some dates. I don't know if it's even feasible at this point, Mr. Kessel, to give me a time.
This is perfectly normal pre-trial stuff. A lot of things is about scheduling, because especially when a case has multiple defendants and a civil case going, shit gets complicated. And as an example, this case is, what is it? 4 months in. And for as an example, it took from arrest to start of trial in the YSL case, it took a year, almost 2 years. So the more defendants, the more complicated it is. And where is Mr. Jingles? Mr. Jingles is outside. I heard him go in and getting some snacks downstairs, and then he walked out again. So no appearance from Mr. Jingles today, it seems. He's doing something outdoors, which I probably will see the result of in the morning.
An amount of time that I would need to set it aside for you to present witnesses, it's probably too soon to even guess what the length of time for an exam, at least on the part of who you would be presenting.
Yes,
would take
Edward,
us. But
that
I
is
also would like to
exactly what
confirm
Mr.
that,
Jingles
because
is
everyone seems to
doing
be talking
outdoors.
about an exam as if we are certain it's going to take place together with all four defendants and all four attorneys. Is that your intention?
Yes, Judge. So, Judge, I just have been sitting quietly for a couple minutes. A couple things. First, I appreciate everyone's thought on the power that my office had, but we can't just tell a circuit court judge to go stuff it and we're going to do what we want to do. It's unfortunate for all of us that the civil attorneys jumped in and got this TRO, but while that
Folks, does that look like an AI person? That's a really I'm sure Chris Kessel is a very competent attorney general, but damn, that looks like an avatar.
TRO is in place, we are all bound by it. And there's no, Mr. Flood was a prosecutor. There's no magic wand I wave that makes judges do whatever I feel like telling them to do. So I think I agree, Your Honor, that I think what we need to do is come back when we know when this inspection is going to be, because I agree with all the defendants. They all should have their experts there. I certainly don't think the civil attorneys should, go first. And I think that's what the defendants have the right to, right? So I think I'm on board with everybody, specifically, I think Ms. Sharon. Let's come back at the end of May. Hopefully by then we will have a date. And if there's, for lack of a better phrase, if the civil attorneys keep messing around, then maybe we collectively need to go to Judge Brennan and say, look, you can't hold this proceeding hostage while the civil attorneys, are I'll refrain from saying what I actually think, Judge, but while they're messing around trying to figure out protocol, we've got 4 defendants who have rights. So I think that's the move, is if we set a new date for a PCC today, if there's any more delay with the civil attorneys, I think we can all try and go to Judge Brennan and get something done, and then we go from there.
All right, so I'm looking at a potential date. I can obviously set this on a date other than my state law matters or docket. I know that I have June 9th, some open time in the morning, where we could schedule a PCC without other cases that are currently set. It would probably be set at 9:30 or 10. Is that a date that the parties are available?
Yes, sure.
Fine for me.
I am not. I'm supposed to be in the middle. I'm supposed to be starting a trial that morning in Oakland County Circuit, and it will last a couple days. I know that I anticipate that Wednesday morning trial wouldn't go because it's motion day, so I could be available perhaps Wednesday morning of that week on the 11th, or I would anticipate by Thursday that the trial would be over. And if not, I would just ask the judge to accommodate some time for a PCC, Your Honor.
I'm available on the 11th, Your Honor.
Okay, well, this was a lucky Wednesday morning for you to come in here, because normally I have either my treatment court or I have Operation Drive pretty much every week. That's what my Wednesday morning looks like. So let me see what other options I might have for a Wednesday. What about on the May 28th in the morning, but a little bit later at 10:30?
That's fine for me, Judge.
Second.
I'll be on vacation, but I'll make it work, Your Honor.
Okay.
You have a federal sentencing at 10. If we could do it at 11 or later in the morning, I can appear by Zoom.
Mr. Flood, are you available?
I will make it work, Your Honor. I have some things I have to work around, but I don't want to hold this up. I'll make it work.
Would 11 o'clock in the morning be okay, Mr. Flood, then?
Yes,
And that will give you a little bit.
that would be preferable.
Okay, that will give you a little bit more time to sleep in, Ms. Sharon, on vacation. 11 o'clock.
I'll be 3 hours earlier, so it'll be early regardless, but that's totally fine, Judge. I'll just be zooming in from a hotel room as long as that's okay with Your Honor.
I think that would be fine, and then I'm hopeful that your clients can make that date work as well. I'm trying not to add in another set of responses if I can avoid it, but obviously if you speak with your clients and there is some exigent set of circumstances that would cause them to not be available on that day, I will be open to address it after we're done here. But for now, let's set the adjourned PCC May 28th, 11 a.m. As has been my practice here with this case and most PCCs, I am going to allow all of you to appear remotely using Zoom if you agree. and you're in compliance with bond, which is the information that I have today, that all 4 of your clients are in compliance with the current bond conditions. I am going to keep Mr. Flood, Mr. Kessel, and Mr. Markin on to address the motion that was filed by Mr. Flood. Does anyone else have anything that needs to go on the record prior to doing that?
Your Honor,
I do real quick, Judge.
Okay.
Oh.
I'm gonna make you.
Go ahead, Jerry.
Your Honor, I did locate the TRO. I sent it to Ms. Ebersol. It is limited to the Kurtz Boulevard address and the contents there. So the court, I did supply that to the court, but it, in answer to your earlier question, it's a fairly limited TRO to the scene of that we need to investigate.
Thank you. You read my mind, because that was going to be your homework after I was dismissing you from the PCC today. So thank you for doing that. I'm assuming everyone else has a copy so that it would need to be circulated to everyone. But of course, if that's needed, I would like to make sure everyone has the exact same information that I'm receiving. Thank you, Mr. Gleason. Is there anything else, Mr. Kessel? I think you were going to say something.
Yeah, Judge, real quick, I've circulated a proposed order to all the defense attorneys. There were some investigative subpoenas that were conducted. Obviously, I'm sure the court knows by statute, I have to get a court order to release them to everyone. So everyone's agreed to let me e-sign them. So I will have my secretary get those over to the court today. And once those get entered, I can disperse the 3 transcripts to everybody.
All right.
Thank you.
I'll look for that. Anyone else, except for Mr. Flood and Mr. Markin, have anything to place on the record at this time?
No, Your Honor.
No.
All right. Thank you. The 3 attorneys and their clients can be dismissed. I'll see you on May 28th at 11 a.m. And all of the 3 of you have your bond conditions continue. Thank you.
Thank you.
Sure.
Thank you, Your Honor.
All right. So we're remaining on the record here. Only
Jacob's proud mother. How peaceful is it on your farm? It is very peaceful. I mean, I have about 100 yards that direction to a neighbor and 150 yards that way to the other neighbor. Now, there are farm equipments, because this is farmland where I live. So there's farm equipment. You can hear all the equipment, all the tractors and all the stuff, all of that when they start. But other than that, I can go outside and I can hear the highway, which is about half a mile away. But other than that, it's silent, and it's really, really good. It's really, really good. All right, let's see. It is
with the matter of the people versus Mr. Markin. And this specifically is for the purpose of addressing the motion that was filed on behalf of Mr. Markin regarding a request to modify the bond. So I reviewed the motion and the lengthy set of exhibits, I guess letters of community support that were provided. I did not get a written response from the people. Are we proceeding with the motion, Mr. Flood?
Yes, Your Honor. Yeah.
Okay. And Mr. Kessel, I guess I'm going to let you respond if you choose to place something on the record verbally, but can you confirm for me whether or not you did file something at the court that I should have received?
No, Judge, we didn't file any written response.
Okay. So, Mr. Flood, if you'd like to place anything in addition to your motion on the record, I'm happy to allow you to do that. I do want to start by asking a question, and I'm meaning this in the most respectful way, only because I know that you were not present at the arraignment and that Mr. Kassar was present with your client. So you were not there on that day. At least that's what I understood. The appearance came in after the fact, and please correct me if I'm wrong.
No, you're absolutely.
Okay, I assume, though, that you received a copy of Mr. Markin's pretrial release order. Did you receive a written copy of that order?
No.
Okay, so when you filed your motion here with the court requesting a modification of bond, and you placed in the motion that the basis for the request was your belief that your client was ordered to wear a GPS tether upon release if he posted his bond, and that he must remain at home and had home confinement ordered with no exceptions. Were you placing that argument in your motion based on a report that Mr. Markin had given you about his bond conditions, or where did that information come from?
That's what I received from my client, Your Honor, that he was not allowed to leave his house while he was on tether, home confinement.
Okay.
So that's our understanding. He can go around his yard, in essence, but that was it.
Do you mind?
I don't have an order. I don't have an order from it.
Sure. Do you mind if I ask your client to unmute himself and just simply ask him where he received the information from that leads him to believe that?
I don't.
Mr. Markin, can you please unmute yourself?
We listened to the arraignment just an hour ago, and I believe the client is mistaken. He was not allowed to go near a lot of facilities, and he had to wear a GPS, and he was not home confined, but he within time limits, if I remember correctly. But that should have been in a written order.
So you can answer my question?
Yeah, so I'm unmuted.
Okay, Mr. Markin, did you hear what's going on here? Your attorney filed a motion and he signed it, indicating that everything contained in the motion was true to the best of his knowledge. And in that motion, he's asking for an ability for you to travel outside of your home. He's asking for a specific radius, right? But a big part of the argument that he's making is that he wants you to have the ability to leave your home and come to meet with him for purposes of preparing for this case. Do you understand that?
Okay, yes.
And what is it that you were told and by whom that makes you believe you don't have the ability to do that?
Well, I was told that I was allowed to meet with my attorney. And, you know, my whole purpose of this was to go to church, but, so I guess I'm, you know, responding to it that's what I was understood that I heard.
Okay, so you do understand that when you were told that part of the bond conditions required you using a GPS tether to track your movements, and while for the most part, the expectation would be that you're at home, you had the ability to leave your home for certain reasons. So did you understand that?
Yes, I understood that. It was to go to a doctor's appointment or see my attorney.
So actually it was more expansive than that. And everything that I could see either in the pretrial release order that you received, as well as the bond compliance reports that I get from your pretrial services case manager every time you come to court, it's more expansive than that. And so I was a little bit confused that your attorney spent what appeared to be a ton of time preparing this motion and gathering a number of letters from community members where their names are now in the public record and this information is accessible to people. And he's asking me to grant you permission to do something that you can already do. So I'm a little bit confused by this.
Well, yeah, and I'm also confused by that because when I called in to Melissa Lane, she gave me my instructions, and that was to be a house arrest, perimeter to go see my doctor or my attorney, and with permission. And that was it. That was the extent of it.
So,
I couldn't go to church. I couldn't go anywhere else. That was my limit, and that was how Melissa explained it to me.
So from the court order that
This is why you should everything in writing. Don't just call and listen. Get it in writing.
I have, that has not been modified as far as any of those restrictions since the date of your arraignment before Magistrate Chappelli, which I think was March 11th. You were given home confinement, which basically means that you're home base. So that's the expectation that that's where you are when you're sleeping at night. And if you're not out of the house for one of the permitted reasons that were outlined by Magistrate Chappelli, that's where you're expected to be staying. And you were given the ability to leave your home for anything related to court, meeting with your attorney, employment, going to the doctors, any other medical appointments. And I believe there might have been something else. Let me make sure. So anything to do with meeting with your attorney, preparing for the case, medical, anything related to appearance in court or conditions of bond, and employment. So
Yeah, but
to me, that seems as though you have the ability to do a number of things, anything that would be necessary. But your attorney did not convey that in the motion. He appears to be under the impression that you were told you had to stay in your house and could only go in your yard, which is not what the court order says. So I'm trying to
Right.
figure
Well,
out where the discrepancy is.
yeah, and I am too. So in my conversation with Melissa Lane, I was told I couldn't even go to my mailbox because the distance was within 500 feet or so. So she was very specific that I was confined to home and I would have to request to see my attorney or go to my doctor. And that was it. My original ask was to go to church, which is, miles away. And she told me I would have to go and get an approval through that. I wouldn't be able just to ask her for the request. So I'm kind of surprised also, because I have been very diligent and confined to my house through this whole process. And that's how Attorney Flood has, that's where he's getting that from, is that it was what I was told.
So I think the other issue too is just administratively how they enforce the court's order. So it's my understanding that when someone has the requirement of a GPS tether and they're told that they have home confinement, which as I explained, that means that's home base, that's where you're sleeping at night, but they have permissible reasons to leave the house. I think the issue that you're having, Mr. Markin, is that yes, these specific items have been carved out for you, but the way pretrial services manages those requests and confirms them is that you have to actually make the request to do something ahead of time. And so if the court has ordered that you have home confinement, but you can leave to work instead of just getting up in the morning and heading out the door at 8 o'clock, for example, to say I'm going to work and I'll be back at 6 and expecting the pretrial services caseworker to say, okay, the issue is that you have to be able to present something ahead of time that says I'm employed, this is my work schedule. They have to acknowledge that they've received it and it's been verified. And then there's no issue with you leaving. And the same goes for meeting with your attorney. I know your attorney had referenced that there's a great distance between the two of you in terms of how far away he is. And of course, there are certain things that I know you'll want to do where you'll meet with him in person. I don't expect that you only meet with him remotely because you've selected an attorney that lives further away from where you, or is working further away from where you live. But instead of just picking up and saying, oh, I'm leaving and I have an appointment with Mr. Flood at 2, that's where I'll be. You would have to advise the pretrial services caseworker, you have an appointment with Mr. Flood, it's scheduled for 2 o'clock. If they feel as though they need to verify it with him, they would do that. And then you have the approval to go. So there's a little bit of a process, but you are able to make all of those requests as long as they fell under those parameters.
Right. So
Your Honor?
Yes, I think Mr. Flood probably wants to weigh in here for a minute, so just hold on.
If I may. Thank you, Your Honor. I think there was a little bit of a lack of communication with regards to what pretrial services was saying and how restricted this may be, and the understanding of what I received, the information I received, because it sounded to me as this was kind of a prophylactic measure. You had home confinement, and you also had a tether, confirm home confinement. That's the way it came across to me. What I'm asking this court to do, if we can amend this order, and that's, a big part of, bond. 1, what's the likelihood of him to return? And 2, what's the threat to our community? If I could have my client have the access to be able to travel without checking in between a certain period of time. Let's say 9 o'clock on Sundays to throughout the week from 9 to 3 p.m. Yeah, you know, so he could have that flexibility of traveling. It would make it, I think, ultimately, it complies with the court rules. It complies with the statute. I think we have the burden. One of the few times in all of criminal law, a defendant has a burden, that of an affirmative defense and that of bond. I think we can meet the burden to show that Mr. Markin is not a threat and is not a flight risk. And that leeway, I think, will make it much more convenient because our schedules, my schedule, as you can see, is crammed. And there can be spontaneous times where I say, hey, listen, I just received A, B, C, and D. My schedule freed up. Can you meet me halfway today? Can you meet me, you know, it's 100 miles away to Spring Arbor. That's why I asked for 110 miles. It's from Detroit downtown by the federal building to his house is 100 miles. If I want to meet him in a spontaneous thing, hey, listen, I want to go over this. I have some time. It saves us from going through the pretrial services. I'm asking for that. I don't believe the government, Mr. Kessel, has a strenuous objection to that. Maybe he does, but I don't want to certainly speak for him. But you can see from the writings, my writings and my papers, that the Markin meets the checklist times 10 as it relates to why that might be convenient, or why that we meet our burden with regards to setting some sort of leniency on that bond provision. I'm not saying take away the tether. I'm not saying take away home confinement. I'm just asking for a period of time. And the other thing is for his worship. He has a big family. He's has strong religious beliefs. He goes to church on Sunday. Those types of things to check in. It doesn't always work. I've been through this rodeo a few times with regards to checking into, having clients check into pretrial services, and it not always being accessible.
Okay, did you have a response, Mr. Kessel?
Judge, I think for the most part, I'm just going to leave it in the discretion of the court. You know, I don't know exactly what goes into the checking in with the pretrial services. I'm sure that the court is, and quite frankly, maybe Mr. Markin are more knowledgeable than I am about that process. You know, if I certainly am not going to object if Mr. Flood or Mr. Markin wants to suggest some sort of standing time, particularly on Sundays, if he wants to go practice his faith. I'm not looking to get in the way of that. You know, as far as windows of time where Mr. Markin can be out of his house, you know, like I said, I think I'm just going to leave that to the discretion of the court.
So what I'm hearing is an argument about convenience and a lack of convenience to Mr. Markin, because he has the ability to be outside of his home for a number of purposes on any given day. If there was some confusion in how this was conveyed to him from pretrial services, I will make sure that the process for letting them know that he has a valid reason to be outside of his home that falls under one of the 4 provisions that were given to him by the magistrate. I want to make sure that he has accurate information. I also want to make sure that all of the defendants who have the exact same condition are given reasonable parameters. Unless Mr. Markin's mailbox is in the next town over, I have no idea why he wouldn't be able to go to his mailbox. So we'll make sure that that's not an issue. But at this point, aside
Can I?
No, Mr. Markin, I don't want to hear about where the mailbox is right now, okay?
Oh, I don't.
Aside from wherever it is that he is making a request to attend a weekly, I'm assuming weekly services ad, which I have no issue, and that can be easily provided for in addition to this bond. I think these conditions are reasonable. I think that they cause a little bit of inconvenience, but at the same time, Mr. Flood, because of the fact that the two of you are about 100 miles apart, I would anticipate that most of the meetings that you're going to have with your client will be scheduled ahead of time so that he can get there, or you can meet him somewhere. And this information simply has to be conveyed to pretrial services, and he should not have any issue meeting with you. I will make sure that there's no issue with him letting the pretrial services case manager know that.
My interpretation of this is that Mr. Markin wants a free to leave between 9 a.m. and 3 p.m. as long as he gets back to his home at 3 p.m. And on weekdays and on Sundays, so he doesn't have to call pretrial services every time he needs to go somewhere, other than to his attorney. Then he just if he's going to meet his attorney, as I interpret, he only needs to tell the pretrial services in advance. If he has work, then his schedule will be told to the pretrial services, so they know, okay, he's going to be at work between 9 and 3, somewhere of the sort. This is more lenient than most other I have heard in all the cases. I've been covering some 40 different cases on my channel throughout the years. Well, the past soon to be 3 years. And I have a bunch more that I'm reading, which may or may not get to you guys, just in case, okay, this can be interesting or whatever's. But this, I mean, he's out on bond for a really, really serious crime. And it seems like all he has to do is to, hey, pretrial services, church Sunday. Now, if they start denying him that, now there's an issue. But it seems like he was under the impression that he wasn't even allowed to ask. And this might be because pretrial services he has a lazy handler or something of the sort. So he wants to have it more convenient than it is now, and I don't. And it seems like, why doesn't his attorney have the bond restrictions documents? Yeah, it's strange, but all in all, it's inconvenient for Mr. Mark, for this defendant, but it's really not that restrictive in comparison. Tofu Brains, why is this bond more restrictive than Karen Reed's were? Well, because it's another state, another jurisdiction, I would assume. So but it seems like much of this is miscommunications and misunderstandings.
He has appointments to meet with his attorney, to come to court, to comply with any other bond conditions that he's been given, to not only be employed, but if he's choosing to seek employment, and I will make sure that it's very clear for all of the defendants what they would have to do to put the pretrial services case manager on notice that they have these obligations so that they can meet them. And I think it's very reasonable that if he is someone that regularly attends church, he simply has to tell me what day he goes, the timeframes in which he is there, and I'm going to add it to the order so he doesn't have to check in with pretrial services to get permission to go to church. But what I'm hearing really seems to be more of an argument that's out of convenience for him. He seems to understand that he had the ability leave his home, even though that wasn't really how it was conveyed in the motion, but perhaps he didn't have a clear understanding of how to make that happen so that he could actually utilize those exceptions. But I'd like to keep everyone in the same place as far as the conditions. I think they seem reasonable, especially given where we seem to stand in the case, which is with still a lot of questions that need to be answered, and that the attorneys are hopefully going to get some answers to when the inspection is completed and when we proceed to exam. At that time, of course, I'm assuming I'll have more information about the allegations that have been levied against each individual. And if I need to make adjustments at that time, I'm happy to reconsider this really at any time. But I think that we just need to make it clear what the process is for Mr. Markin to be able to leave. I don't find that there's an appropriate or really reasonable basis to treat Mr. Markin differently than everybody else has been treated as far as these conditions. And I think maybe with a little bit of clarification to pretrial services from the court, which will then be provided to each of the clients, I'd like to make it easy for them to utilize the exceptions that they've been given so that we have a sense that home is where they are going to spend a good deal of time right now, at least, or at least stay there for the evenings and the foreseeable future. But I'm not trying to keep them in their homes for months on end, but I do think that everybody should be able to operate under these exceptions at this time, with Mr. Markin being able to leave to go to services as well.
Thank you, Your Honor. There's one issue, Judge. His property is about a half mile. There was a strict order. His mailbox is, I've been to his house now because of this confusion, to say the least. And his mailbox is down the road, which is about, I would say, maybe a driver and a pitching wedge, maybe about 500 yards. I don't know. And he has about a half mile radius of his property. He was told specifically, he couldn't go to the mailbox down the end of the driveway, about 500 yards, and he couldn't go outside of like a 10-foot radius of his home. So if I understand this court correctly, you're saying that he can walk the perimeter of his house and get down to the end of the street where his mailbox is and the like. That shouldn't be a call-in to the pretrial services.
No, I wouldn't think so, but I also, from my understanding, Mr. Markin is not living alone at home. But if this is a real big issue for him, I am happy to make sure that pretrial services makes the appropriate accommodation for him to get the mail. I don't want to spend too much more time on this. I'm trying to be thoughtful. Mr. Markin, I got it. Can you just tell me what day do you typically attend service?
Well, I typically attend service on Sundays, and I typically lead or have a Bible study on Tuesdays and Thursdays with a bunch of men. We have a service or a fire church that we actually have that is on our property, but my property connects. I have two families that are also connected. We're all connected. My farm or our farm is in the center of all of those properties, which are, maybe 2,000 feet or 3,000 feet from each other. But I can't, that would be my job right now as I'm retired, is working on the gardens and the chickens in the farm. And the way that this is set up, I can't do any of that because I'm not allowed to go that far away. Because it's on my son's address, which even though it's my farm, which is right next door on the same 40 acres.
So you have a farm, your family lives on this compound, and there's a church where you
We all do.
complete Bible study. Okay, Mr. Flood, can you maybe send over some information and include Mr. Kessel?
I will.
So I have a better understanding of what I am dealing with. So, sir, the actual location that you attend service at, you're telling me that's on your property? I'm just mostly concerned about Sunday right now.
Yeah, the church on Sunday is about 6 miles away.
So if Mr. Flood could please provide the specific information about the location and the times in which he would be leaving so he could attend service on Sunday. If you can just send that over to the court so I can get the order updated and sent to pretrial services. And then anything beyond that, I'm probably going to need a little bit more information, as I'm assuming Mr. Kessel might, if we are going to try to navigate what seems to be an unusual set of circumstances about the property. And then I'll follow up with pretrial services when the order has been changed, just to make.
I mean, my property is 46 acres. I'm trying to understand how he can have 500 yards to the mailbox if his property is in the center of 40 acres. I don't see how that works. I don't see how, since my farm is of equal size to him, how does he have 500 yards to the mailbox? That means the mailbox must be at least 200 yards outside of his property at the end of the road. I'm just
sure that I have a very clear understanding of the instruction that they are giving Mr. Markin, as well as the other defendants, about how to make the requests in a reasonable
his
amount of
mailbox
time
is
so
not
that
on his
they
property.
are all permitted to meet with their attorneys, do anything that is required by the court, attend medical or other related appointments, and then how to seek and then maintain employment if it's secured and verified. So if there's any additional information that I receive, that should be shared with all of the parties here to make this process, I think, efficient, maybe a little less cumbersome, or if there are questions that people have that they just have not asked at this point, but Mr. Markin has, hopefully this will smooth the process out so that we don't have any issues and we can just proceed to the next hearing, the PCC, and then the exam beyond that. Are we comfortable with that?
Thank you, Judge. You've been great. I will do the what you requested.
All right, Mr. Kessel, you're all right with this as well?
Absolutely, Judge.
All right, very well. So we'll make those changes after I get the information from you, and we'll be able to process them later on today. I'll see all three of you on the 28th.
Have a great week, Judge. Thank you.
Thank you.
Thanks, Judge.